Welcome to an analytical look at one of the most crucial, yet often overlooked, provisions of the Indian Constitution, Article 6. This discussion is essential for law students, UPSC aspirants, and anyone interested in the foundational history of citizenship law in India. We begin with the crisis of partition. While Article 5 defines citizens already in India, Article 6 was the legal tool created for the millions who migrated to India from territories now comprising Pakistan. Why was Article 5 insufficient? Because many migrants arriving in India didn't immediately meet the strict domicile requirements. A new framework was necessary. Article 6 stands as a constitutional exception, designed to confer citizenship on migrants who came to settle permanently in India, following the tragic events of partition. The core purpose was humanitarian, to provide a clear, legal path to citizenship for those displaced and seeking permanent residence in their new homeland. The most critical date in Article 6 is July 19, 1948. This date marked a significant shift from a lenient, automatic conferral of citizenship to a stricter process requiring formal registration. For migrants who moved before this cutoff date, the test was relatively lenient, involving two main criteria. First, the applicant, or their parents or grandparents, must have been born in undivided India, establishing that essential ancestral link. Second, they had to be ordinarily resident in the territory of India since the date of their migration, proving their intent to settle. For migrants who arrived on or after the 19th of July 1948, the rules became much stricter, requiring a formal application for citizenship. These individuals, in addition to the Ancestral Link, had to be registered as citizens by a designated Government of India officer. Crucially, they had to prove continuous residency in India for at least 6 months, immediately preceding their application for registration. The legal mechanism enforcing this cutoff date was the, permit for resettlement, introduced right around July 19, 1948. This permit governed the legal status of movement for those who may have returned to India after having initially left for Pakistan, thus defining who fell under the stricter rules. The permit system effectively cemented July 19, 1948, as the defining legal moment for determining the pathway to citizenship for partition migrants. To conclude our analysis of Article 6, let's reflect on its profound impact. Article 6 was a powerful humanitarian constitutional instrument that successfully addressed the massive demographic and legal challenge of partition by providing clear, structured pathways to citizenship for those displaced. Please comment below. How did the 6-month residency rule ensure the seriousness of permanent resettlement? And stay tuned for our next video, the legal status of Jammu and Kashmir migrants under the Constitution.